Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the topic of Mensrea. Mensrea means bad intention, guilty intention. So while discussing the topic of actus reus, I told you that for committing a criminal offense, normally Mensrea will be there. So maybe in the name of motive, intention, preparation, planning, attempt, and ultimately it results in the act. Actus reus. In cases of outraging the modesty of a man, mere bald statements are not sufficient. Only vague assertions are not enough to prove the case of outrage of the modesty of woman. This was stated by Honorable Supreme Court of India, two judges bench, that is Justice C.T. Ravikumar, who retired recently, and Sanjay Karol. The case law is Naresh Kumar Aneja. Naresh Kumar Aneja versus State of Uttar Pradesh. SLP number 1093 by 2021, decided recently on 2/1/2025, wherein it was held that to establish Mensrea in a outrage 354 IPC case, something more than vague statements must be produced. This is very, very important. Right? So the application of force must be coupled with intention of outraging. Two aspects should be proved beyond all reasonable doubt. In order to establish the topic of Mensrea, mere bald assertions are not sufficient. So that mental and physical discomfort were caused, it is not sufficient. Please remember, something better than the vague statements is necessary. Let us go to the case. So here it is a dispute between joint directors of a company. One is a male and the other is a female. Appellant and the so-called respondent, they were the directors in a joint concern, that is Messrs. LAJ-IDS Exports Private Limited. Of course, as usual, disputes arose between them regarding the maintenance or financial matters. Actually, the appellant wanted the respondent to go away from the place. Let us, since the disputes arose regarding the financial matters or the mishandling of the company's accounts, so actually better to end the partnership. Therefore, the appellant sent a notice to the defendant. So let us say bye-bye to Ishvara. That means better to withdraw. So this happened in the year 2019, July. So the appellant sent a letter to the respondent, better to end the partnership. But she did not keep quiet. On 27, 2019, in the same month, she approached, she filed a complaint. It's a private complaint actually. She filed a complaint against the appellant and also his brother that their behavior was inappropriate. Actually, still let us come straight away to the topic, that is outraging the modesty. 354 was registered because the appellant held her hands tightly. This is the allegation. చేతులు పట్టుకున్నాడు. సో ఇంటెన్షన్ మే బి దేర్, బట్ చేతులు పట్టుకున్నాడు అనేది హెల్డ్ హ్యాండ్స్ టైట్లీ. సో దట్స్ నాట్ సఫిషియంట్ అని సుప్రీం కోర్ట్ చెబుతుంది. సో యాక్చువల్లీ ది అపెలెంట్ అండ్ హిస్ బ్రదర్, దే మిస్బిహేవ్డ్ ఇన్అప్రోప్రియేట్లీ టువర్డ్స్ ది respondent in the workplace and threatened to murder her by holding hands. ఇది ప్రాబ్లం, రైట్? షీ స్క్రీమ్డ్, షీ ఎస్కేప్డ్. సరే, చాలా స్టోరీ అంతా జరిగింది. ప్రైవేట్ కేస్ కోర్టులో వేస్తే ద ఆనరబుల్ మ్యాజిస్ట్రేట్ endorsed the same to the police for registering a case. Accordingly, crime number 1074 by 2019 under section 354 and 506 IPC was registered against these persons. Now they have come for the so-called discharge as squashment of the FIR. High Court also did not agree. As such, the matter came before the Supreme Court. So please remember, in the meanwhile, the police filed the charge sheet. Now, Supreme Court has gone to the record and clearly held that Something more is necessary than mere bald or wild or vague assertions that he committed the so-called modesty. Here it is very very important. I think all of you know that modesty is not defined in anywhere in the identity in the Indian Penal Code. But still, every woman, chastity, modesty are very very important for them. No doubt. Here, simply catching the holding the hands on, they do not come under the purview of intention to outrage the modesty of the man, basing on very two important case laws. One is Manik Taneja versus State of Karnataka, 2015, and State of AP versus Aropalli Venkanna, 2019. So, basing on both these cases, Honorable Supreme Court of India was pleased to quash the FIR. So, two important points you have to learn here. Modesty is not defined in the IPC, and for proving the modesty, the intention to outrage the modesty, not only the force, something more than that is necessary. Right, with this I am closing. Please read the case law and enrich your legal knowledge. Thank you.